At the outset, a very warm welcome to all the people who have joined from different locations for this interesting program that we are having today. And I have the privilege of introducing the eminent panelists for today. Today's session, which is where we are on the labor code and basically a refresher and perspective. So we are looking forward to a very interesting deliberation today. So our eminent panelists are, the first panelist is Mr. Anil Bhatt, and he is basically an employment law specialist and advocate at Lex and Craft. Anil started rendering his active professional services in leading employment law firms, and since 2001 advised major domestic and international business houses on various critical employment law issues, and also worked closely with various foreign law firms and HR consulting firms. He has held various jobs on new labor codes at single platform for more than 300 companies. He has held workshop on uh, new labor codes for various companies across countries since 2020, and he has provided support to business chambers for making recommendation for the new labor code. So welcome Anil. And our next eminent panelist is Ravi Birbal. Uh, she's an advocate and on employment, constitutional litigation and corporate law specialist at the chamber of Mr. Raj Birbal, senior advocate. Ravi has already done substantial work on labor codes. She has been regularly called upon by reputed institutions of India like PhD, Chamber of Commerce, Institute of Company Secretaries of India, Delhi Judicial Academy, National Academy of Agriculture Research Management, Adhivakta Parishad, IMT, CAPSI, and many more to address on Labor Code 2020. She has also been taken on board of state government for framing rules relating to labor codes. She has advised several corporate on steps ahead. Ravi on day-to-day represents in courts and advises several corporate and government institutions on various aspects of law. Welcome, Ravi. And our third panelist and the moderator for today's session is Mr. Amitav Adhikari. He is head HR, Agile Airport Services and Interglobe Aviation Company. Amitav is an MBA in HR and a law graduate with more than 20 years of experience in human resources. He has deep interest in labor laws and has practiced labor law in various roles in both manufacturing as well as service industry. He has designed master class on each of the labor code, and these are run on Unacad, Udemy. He also runs weekly video blog, Sunday Gupshup, that details the master class, and blogs are available on his website. And the before we start, I would like to hand over the mic to Amitav to set the context, and we look forward to an interesting deliberation. So over to you, Amitav.
Thank you, Musrat sir, and for this warm welcome. There is a problem with my video; it's not visible. But then let the show continue. So thank you everyone for joining in. I can see lots of colleagues, senior professionals, friends in this call. So we hope that we'll make good use of next 1.5 hours. So let's straight away come into the topic. The labor laws are going back and forth. So where is it headed to? More important is the question, how is the change going to be? Is it going to be big? How will it impact? Will it impact only people in manufacturing or factory, or will it go beyond that? Will the services, ITS, malls, data processing units, commercial places, e-commerce, plantations, will these organizations be impacted? We'll also try to find answers to how is it going to impact the unorganized sector. People who work on gig work, people who are working with aggregators like Urban Company or Ola, how is the law going to impact them? And we'll also try to find out how technology is going to help the life of we HR practitioners make easy in implementing the labor code. So with these thoughts, I will go to the eminent panelists today and will try to find answers to few of these questions. I would start by going to Ravi and ask Ravi on the views on Ravi how the Industrial Relation Code 2020 and the Code on Occupational Safety, Health and Working Condition (OSH code), how is it going to change? What are the big changes with what these codes are going to bring?
First of all, thank you for such a spectacular introduction. Yes, the labor codes are very much about to come. And of course, apart from merger of various acts into 4 labor codes, there are also changes that we foresee, which are like as follows. For instance, as we all know, the well-known concept of fixed term employment that is going to gain a lot of importance. Till now, many people were not knowing about the concept of fixed term employment. As we all know, fixed term employment are people, are workers. If you keep them on fixed term employees, then before terminating them, you need not comply with the provision of retrenchment. However, the new labor codes which are coming that have taken care of certain loopholes and that say that even if you keep a fixed term employee for just merely 1 year time, he or she would be entitled to gratuity. So unlike a regular employee who would be entitled to gratuity only upon completion of 5 years of service, a fixed term employee would be entitled to gratuity merely on completion of 1 year. So that is one key change in the IR code, that there is a slight change in the fixed term employment. Thereafter, a very pertinent change is that the definition of employer has been expanded. Till now, contractor was construed to be an employer only under Building and Other Construction Workers Act. Otherwise, under entire labor laws, say it Employees Provident Fund Miscellaneous Provisions Act 1952 or Employees State Insurance Act 1948, or even under Contract Labor Regulation Abolition Act 1948, 1970. None of the acts were recognizing contractor as an employer. Contractor had responsibilities, but not initial responsibilities. But the new code recognizes contractor as an equally responsible person. This does not mean that principal employer would be obligated or would not be obliged to fulfill the obligations. Primary responsibilities would still remain with the principal employer, but contractor can equally be summoned, which even now he can be. But after the implementation of the codes, even with more force, the principal employers can validly argue in court that contractor is also taken to be an employer as per the code, and for any non-compliance, he should be also be summoned by the authority. Then another big change is going to be, which is really talked about in terms of definition of wages. So as of now, as we all know, sometimes companies do subterfuge, camouflage to kind of reduce liabilities of gratuity, PF, etc. But the new code takes care of this problem also and says that at least 50% of the CTC mandatorily has to be basic and DA. Now, after this change, a lot of questions come to us by people saying that, would this kind of increase the gratuity? Would this kind of increase the PF? So answer is yes, with respect to gratuity, there could be huge liabilities because 50% of the 50% CTC basic DA, that would be a huge impact. But with respect to PF, there may not be a big change because the code retains the fact of PF being deposited only on a cap of rupees 15,000 or whatever the statutory cap that may be. Then another change would be with respect to standing orders. As of now, standing orders are to be maintained by organizations who have got 100 or more employees. But because the new codes wants to make compliances less and wants to make it more employer friendly, therefore standing orders would now have to have by the organizations having 300 or more employees. Then another huge and a positive change is going to be with respect to strikes, that now no urgent strikes, cat eye strikes as we call it. People can go on strikes only after giving a due notice of about 7 days, 14 days. And this notice, 14 days notice, and this notice is going to remain valid for a period of 60 days. If 60 days expire, settlement has not taken place, strike has also not taken place, then thereafter they will have to give a fresh notice. Further, even during pendency of conciliation proceedings and after conciliation proceedings finish 7 days thereafter, or even during pendency of proceedings before Labor Court Tribunal, there cannot be a strike. After the proceedings conclude before Labor Court Tribunal, only then there can be a strike or a lockout. Then thereafter, there has been a change with respect to, retrenchment and closure. Till now, wherever there are factories, mines, plantations, there are 100 workers or more than 100 workers, then a permission of appropriate government is to be taken before retrenchment or closure. But after coming of the courts, this 100 threshold is now become 300. So if you are a factory, mine, plantation, and you've got 300 or more workers, you would be required to take permission. If you've got 300 less workers, your factory, mine, plantation, no permission from government is required before closing down. I may clarify over here, for shops and establishment, there is no requirement of taking any permission from the appropriate government. You may have thousands of workers, lakhs of workers, but no permission is required. So this is again a positive change for factory, mine, plantation, that you can actually comfortably close down if you have got 300 less workers without the permission of the government. All you have to do is send a simple intimation to the government. Then another very important change is with respect to the constitution of labor courts and industrial tribunals. Till now, we only have one judge in labor court industrial tribunal who is a judicial member. But after coming of the code, after implementation of the code, it will be a 2-member judge. Some of the labor courts will be 2-member judge. Any case of which is not of much importance, that would go on before the judicial member only. But if it is a case of much importance, or if it's a high stake case like regularization, general demand, mass workers termination, etc., that would now be taken care by a division bench. One of it would be a judicial member and one of it would be a member from the government. Then further the reference system of the government will go, which means as of now, till now, what happens is that parties go in for conciliation. If the matter does not get settled, matters get referred by appropriate government to the labor court. So this whole system of reference is going to stand completely abolished. The conciliation officer who's at the government level will try to settle the disputes between the workmen and the factories or the industries within a period of 45 days. And after that period of 45 days finishes, or even before that, the workman can take his case directly to the labor court. So there is no need for the workman to wait first for the conciliation to wait for the report of the conciliation to appropriate government, and then wait for the appropriate government to frame the terms of this reference. So litigation will become easier for the workers and probably even more cost effective for the managements. But yes, managements will not now be able to linger on the litigation. Then another positive development for the managements is that, like now we see in labor courts, people file cases even after 5 years, 6 years, 10 years, and labor courts, considering that they are workers, considering that they are poor people, generally condone their delay. However, the new code specifically says that no dispute would be entertained after a time limit of 2 years. Then further very important development is that the new code mandatorily says, see, right now I'm doing a lot of election disputes of unions, and normally stand we take in courts is that our union is not, we do not have a recognized union. However, the new code says that every organization is mandatorily supposed to have its own recognized trade union. Then further, after pandemic, the code is also considering the aspect of, giving power of exemption to government to kind of exempt industries out of some or all of the provisions of the codes. Then this was about, Amitabh, about IR code. And about OH code, like you asked, so OH code has got 2 major changes. One is with respect to contract labor. Till now, contract labor is applicable only on companies which are having 20 or more workers. But after the implementation of this code, contract labor provisions would be applicable on companies having 50 or more workers. Then secondly, as of now, there are government circulars which say that you have to pay the salary of the employee by virtue of account transfer. However, but it's not made mandatory as per law. However, the new code has made it mandatory that any payment to contractors, workers would be made only by account transfer by the contractor or whoever. And if supposing for some reason the contract labor is involved or situated in a remote area, and that you are not able to make a bank transfer, for that purpose you will need to take a specific permission from the appropriate government. Then thereafter, the code also says about one registration. If a company is having branches in various states, it can have just one registration. The contractor would also have the benefit of having his license valid for a period of 5 years. And a very, very pertinent change, which is going to really increase the outsourced labor across the country. And it's going to make it more easier for the companies to have outsourced labor without having fear of regularization, pay parity, and reinstatement claims, is that the code now says that activities which are not the core activities, like the support services, courier, watch, ward, sweeping, cleaning, gardening, which are not the core activities of an organization, these would not be construed to be core activities. These would be non-core activities, which in simpler terms means that now government will not have the jurisdiction to issue a prohibition notification, which means the government cannot ban having contract labor in such support activities. So companies can at ease have contract labor in any of these activities without having fear of regularization. Of course, precautions, as we suggest, that don't have them for years together, that the companies will have to maintain. Now, this was about contract labor. And one more, of course, important change with respect to contract labor in OH code is that now contractors have been obligated, the employers have been obligated to issue appointment letter and an experience certificate to their worker. So whenever, the workers go for regularization claims, pay parity claims, reinstatement claims against the principal employer, and they have gotten an appointment letter as per law, experience certificate by the contractor, then the principal employer can validly show that before the court. So this was important change about contract labor. Another very important change in the OH code is with respect to audio-visual workers. So till now, cinema workers, city workers who were governed by the City Workers Act, they only included workers who were in feature film. But now the term audio-visual stands stated in the Act, in the new code. And whether it's now a feature film, non-feature film, actor, star, a director, a music person, an artist, a cartoonist, animation, whether it's a web-based program, it's a chat show, it's a feature film, it's a non-feature film, any kind of audio visual production, the workers will be given the benefit of labor laws. And here I may clarify that, look, workers in these fields were always having benefits of labor laws. It was not that maybe they were not governed by Cine Workers Act, but they were always having privilege of Industrial Disputes Act, Contract Labor Act, Employees Provident Fund Miscellaneous Provisions Act, ESI Act. Who would be the new beneficiaries now would be the stars, the actors, because they were considered to be professionals. So that would be a new addition. And another new addition would be, and that's going to be a huge change, for which even representations have been made by companies. It is with respect to, working journalists, because the working journalist definition would now include even the digital and the media and the electronic media. So that would mean anybody who is into online industry, the journalists who are into online industry, they may get the benefit of wage board. And as some of you may not be knowing, wage board is a special wage board constituted by the government for the working journalist and the non-journalist class working in the media industry. Like a common workman has got minimum wages for him, working journalists, non-journalist employees in the media industry, they are governed by wage board, which has got rocket high salaries. I am personally doing a lot of cases like that. So by inserting the word in the codes of digital and of electronic, that may give the benefit of higher wage structure to a lot of people in the media industry, for which the representations have been made. Apart from that, one more important change for the women around is that women working would become easier, and women all across the country can be made to work for lengthy hours and for longer durations, even in hazardous procedures, subject to precautions and permission. So these are some of the important changes of the IR code and the OH code. There are many more, but these are the important ones.
Thank you, Ravi. So sweeping changes, Ravi, as you said, and of course, audiovisual workers, quick pick. So even people like us who work on content, if we were to work with the industry, we will be called audiovisual workers. So it's so big a changes, so big a change which is happening. And then you talked about working journalists. So that is again the big change. So we are clearly, to my mind, the labor law is very futuristic in terms of we have captured the future industries, we have captured the workforces, the work of future, and that has been provisioned in law. And of course, we'll talk more on it as we progress. Ravi, if I were to sum up the big point that you shared, On OSH Act, you told about the regularization, the risk of regularization that we had on core and non-core, for which so many court cases had been fought. I think this would be addressed, settled. Then the experience later to contract labor, and that's going to probably make a huge change. If you look at the difference between a person who is on a regular employment versus a person who does a contractual work, the experience certificate itself will set a regime of discipline, and I'm sure that
Yes.
that's going to create a huge opportunity in terms of getting more committed employees, so and we'll get more productive employees. We also talk about working journalists, and that is again, I believe that these were the people who were not in the mainstream, and they were the neglected force. So now that they would be merged into the mainstream laws, and with all the inspection and all, the focus would be clearly would be on the compliances. So these were on OSH. On IR code, you talked about litigation would be pushed on a time-bound manner, and there won't be any scope for manipulation for vested interest. Strikes, yes, the mechanism of strike is such that probably there won't be any strike at all. So there are enough tools and platforms which could force both the disputing parties to come into a negotiation and get an amicable settlement to the strike. And we will probably be saving lots of man hours on work closure, stoppage, conciliations. So probably that will definitely increase the productivity. Claims, as you said, will be time barred, so there won't be a sword hanging on the employers, and exemption, provision of exemption to the industry. So big changes. And thanks, Ravi, for highlighting this. We will reach out to you to understand more on the other provisions. So there is BD and cigar workers, building construction workers. If time permits, we'll also take your views on that. I will now go to Anil. Anil, tell us about the other two codes, the code on wages 2019 and the social security code 2020. So what are the big changes you see, and how is it going to impact us HR professionals?
Thank you. Thank you, Raviji, for a nice compliment. You emphasized it so well. So permit me, I think, Amitabh ji, you have some voice cracking. So then it will be on audio only then.
Sure. So, Anil, could you listen to my question? What
Yeah.
pointed?
Yeah, I could make out that.
Okay.
Okay. So, first of all, we hold all 4 codes, then 44 central legislations being subsumed in 4 different. And when we talk about the code on wage, it was 2019, the first code among all the 4 codes. This code subsumes 4. That's Payment of Wages Act, Minimum Wages Act, Payment of Bonus Act, and Equal Remuneration Act. These are the four put in one compartment, which now deals with matters related to wage, bonus, or issues incidental to that. So that's the scope of this code. Just let's see the major takeaways of this code. Like it deals with the minimum wage. It deals with the payment of wage. It deals primarily with the definition of wage, which is much talked about for all these 2 years, or the employee and the definition of employee and the worker. And in this worker, there's a concept, fixed term employee, what Raviji also referred to. So, and there are a few other, let's take one by one. When it comes to minimum wages, now the effort has been made in this code to universalize the provision of minimum wage. See, presently many states, you see, we have to understand how it works at present existing law. Right now, you have multiple minimum wages in different states. Every state has they fix the minimum wage on a periodical basis. So it's every state. And there's a methodology how you fix up the minimum wage. Now, what has been done, they have actually simplified and rationalized this fixation of minimum wage. Now, it would primarily be based on geography and skill. the applicability right now, the Minimum Wages Act or the minimum wages are fixed for the scheduled industry. So the Minimum Wages Act has its own schedules, and the industries that fall in that schedule and the employees working there, the minimum wages would be fixed for that. Now that has been done away with by this code. Now it applies to all, not limited to scheduled employments, or not. It in fact would apply to all, including employees employed in the unorganized sector. That's something very interesting. Now, it is not linked with any scheduled industry. So it will be linked with the geography or skill. And further, right now we have, let's say, different categories of employees. We all know it's an unskilled, semi-skilled, and skilled. So there's one introduction, new concept that's highly skilled that has been introduced. So when the minimum wages would be fixed now, then it will be fixed for all these four primarily. And while doing that, there is something very interesting. Now, earlier existing, it was only linked to the states would do it. Now the central government has the power to fix floor wages. So what the central government will do, they will fix floor wages for across the country, and it can vary from, dependent on various factors. Now, once that floor wages is fixed, thereafter the state governments would fix the minimum wages if they wish to. Now, that would really slightly, streamline people working in different jurisdictions, different states. That is where the minimum is fixed, and the states would then further, they want to fix and they can fix it further. That's very important so far as the minimum wages is concerned. Next, if I talk about the payment of wages, it's very important that what is present and what's going to be through these codes, then only we will understand the difference and we understand that what is new for us. Let's say payment of wages is concerned. Right now, it has to do with the eligibility so far as the wage ceiling is concerned. And if the employees earning salary wages more than the eligibility criteria, so he would not be covered by the Payment of Wages Act, or barring in few states where the shops and establishment has also really introduced or linked the Payment of Wages Act with the Shops Act, but it is linked with the eligibility wage ceiling. Now, by this code, that is also done away with. So therefore, now payment of wages would be not linked with the wage ceiling. It will apply across. That's something so far as the payment of wages is concerned. I'm just dealing with the broader takeaways under this code. Now, next is definition of wage, which has been actually bothering everyone. And we have been talking about the definition of wage for last 2 years, different interpretations, different people talking on different platforms. I would see how I understand it is that everything is wage. You will have to, before that I actually talk about it, what Raviji was also referring to was that, earlier existing, every labor legislation has its own regime. Some legislations do not define wage, some define only basic wage, and some define wages but in a different way. Now if you see this wage, this definition of wage is across all the 4 codes. So the definition of wage in the wage code is the same in Social Security, is on this occupational, or it's the industrial relations code. So that it makes it very uniform. Now, if you take up the definition of wage, if I would want to prefer to have 3 buckets created for this. Let's say first bucket is where it says that it applies every remuneration, whatever an employee earns as a wage. that I would want to put it in the first bucket. And that includes basic pay, dearness allowance, and retaining allowance. So let's keep it in one and see that everything is wage. Now, if we go to the I think there's some discussion. Okay. Now we take the second bucket, which excludes few components in this structure from the definition of wage, and that exclusion part is the statutory bonus, then the value of house accommodation, the light, water, medical attendance, some amenities of services provided, the contribution towards PF and pension, conveyance allowance, or what you call value of traveling concession, then the sum paid for towards defraying the spatial expenses, house rent allowance, or anything which is remuneration paid under award or settlement, and the overtime allowance. So I would put it in the second. So these are exclusions. Now, what this definition of this wage means, that these exclusions need to be 50%. It cannot be more than 50%. So if this exclusion, if it exceeds 50, that will automatically go to the first bucket and will be deemed as wage. And that is how these two buckets work. And there is one third bucket. That is where the gratuity is payable on termination of employment, retrenchment compensation is paid, or other retirable benefits are paid, or an ex gratia is paid at the time of termination of employment. Now, while having these three buckets in place, what's important to understand, if we all know, let's say the definition of basic wage under EPF Act, and there is exclusion to the basic wage. We all know when we see that how much to be contributed as provident fund on the wages of an employee, eligible employee. So there are exclusions. Now, difference between the existing exclusions would mean, presently, if something is excluded from the definition of basic wage, that is excluded for the good. That means it will never be seen again. It's excluded and it will never be taken into account for the purposes of contribution, meaning that basic wage. But when you see this definition of basic wage in this code, it has a difference. It has a difference that if it is excluded and if it increases beyond 50, then this will come back again. This excluded will be seen again to be seen as part of the basic wage, or part of the wage. Let me give an example, few examples. I think that should make it more clear. I'll give an example. Let's say there's a gross wage of an employee. Let's say he earns 15,000 per month. So 15,000 is the gross wage. And basic wage, let's say he has 8,000. House rent allowance, he has 4,000. And conveyance allowance, he has 3,000. So therefore, 15,000 is divided in three parts. In this case, basic wage would be basic. The exclusion would be house rent allowance 4,000 and conveyance 3,000. Now, if you calculate, the 4,000 plus 3,000 would be 7,000. That means the 8,000 is basic, 7,000 is the components. That means it does not exceed 50%. It is less than 50%. Therefore, this structure is the ideal structure when we talk about, right? Now, let me give you one more example. Let's say a person earns, let's say 15,000 as gross wage. He earns basic as 6,000. HRA, he earns 3,000. Conveyance allowance, he earns 3,000. Now, when basic is 6,000, HRA plus conveyance is 6,000. And there's one more component. There's special allowance, 3,000. So therefore, 6,000 is the exclusion. That means it is 50% of the gross, but special allowance is additional, which will go automatically to the basic wage. So therefore, basic, that is 6,000, plus special allowance 3,000, would be 9,000 would be in this case as basic wage, whereas HRA or the conveyance allowance would be 6,000. So 9,000 plus 6,000 would be 15,000. It's a second situation. Now, if I say third situation, let's say a person earns gross wage 48,000 per month. He earns basic wage 20,000. So let's keep in the first bucket. Now he earns HRA 10,000. He earns conveyance 6,000. He earns special allowance, let's say 23,000. And he earns commission, which is 2,400. And he further earns leave travel concession of 3,000 and EPF contributions 3,600. So therefore, here 1,000 is the adjustment, which is 24,000 would be the amount that has to be, seen as basic wage. Now, issue is what's important is here. When you structure the salary, looking at the wage code is concerned, we will have to do a reverse, thinking that first we fill the bucket of the exclusions. That is the second bucket we fill. And we ensure that that is 50%. And when that is filled 50%, rest can go to the first bucket, right? Now, there could be a situation where you may not utilize the 50%. The second bucket may be 40%. And you may end up having some other allowance which is not excluded as a second bucket. Let's say, for example, I have spatial allowance, which is an extra, that's basic. Then there is exclusions components, and there is one which is a spatial allowance. And my exclusion bucket is only 40%. So I have wasted 10% what I could have utilized. And the third, the spatial allowance, will not be utilized for the second bucket. So it will go to the first bucket, that's of the basic wage. So therefore, it's basic wage, which will go 60%, and the exclusions would be 40%. So that will be a wrong way of actually designing the structure. So therefore, it's recommended that the second bucket needs to be filled first. And then you go to the first bucket. And even if you have something else as an allowance, then 50% rest has to be the basic wage. Why we are doing all this combinations is that we shouldn't end up actually contributing where we can avoid, or we can limit it to 50%. So the impact of it is primarily on the provident fund and also on the gratuity, because gratuity is calculated on basic wage. So once if the basic wage is more than 50%, then in that case, the gratuity, when it will be calculated, will be on more than 50%, which could be limited to 50%. And likewise for provident fund. So the same way, if it is basic and it attracts contribution. So if it is 50 limited to 50, it will be a better structure for the contributions as well. So that's important. While Ravi was also referring to that provident fund and 15,000 more. So if you limit to, this will not apply, where it is more than 15, that will be a voluntary, then you will have a liberty for dealing with that differently, not the way I was referring to. So that will be primarily, the concept of the wage. And next coming to is definition of employee and the worker. So if you see presently, there are different legislations, and when you see different legislations do not have the definition of employee, and few have the definition of employee, which is only linked not with the profile of the person, only with the eligibility so far as the wage is concerned. So therefore, the first time they have defined the term employee, and employee is a broader term which includes everyone except the apprentices under the Apprenticeship Act. So therefore, only difference would be that Social Security Code, when it defines an employee, it also includes the employee who's maybe employed indirectly or through a contractor. So which is not the case with the code on wage, because the employee definition is the person who's worked with the employer. Now, when you talk about the worker, so we have seen worker, we have always presently talked about the Factories Act where the worker concept is there. There is no other legislation where we refer usually to the worker. And there's definition of workman in the Industrial Disputes Act. We all know about it. Now, this is for the first time when the worker has been, defined, and this worker will be in few codes also. Worker is similar to that of the workman under the Industrial Disputes Act. That means a basic definition of, the person who's working on the manual, unskilled, skilled. That is the operational, technical, clerical, or supervisory. So that's similar to that of definition of a workman under the, the Industrial Disputes Act, and would exclude the people working in a managerial or administrative capacity. Something very important in this case is that they have included now the working journalists and the sales promotion employees. It's for the first time here. We were always having a very debate, and it used to be a controversy for a good time, that whether sales promotion employees are there, whether working journalists are there, the profile. Now they have been included within the definition of the worker. So that's something very, very important, and that actually takes away all controversies on this account. So when we talk about the definition of employee and worker, I will slightly jump a bit and talk about fixed term employee here itself, what Raviji was also referring to. The fixed term employee has been defined in other codes, but why I'm discussing here, I would want to take it along with the employee and worker. Now the new law says, and when the fixed term employee, he is employed and works for 1 year or more, he will be entitled to the statutory benefits, primarily the gratuity. The rest may not make difference. And when you talk about the gratuity, so he will not be required the way we have an eligibility of 5 years now. Social Security Code exempts the requirement of eligibility for the fixed term employment. So therefore, the fixed term employee will be entitled to the statutory benefits and primarily the gratuity, which makes the difference now. And when I say fixed term employee, there is a notion, when you talk about people having some kind of a perception that now everything is allowed, permitted. You can employ the fixed term employees the way you want to do it. Just my thought is here that presently in the existing law, if you see the Industrial Disputes Act, fixed term employees is a concept, but these have to be justified. It cannot be a way to avoid employing the permanent requirement employees. If you see the unfair labor practice provision of the industrial dispute right now, that makes it as an unfair labor practice if it is a ploy to appoint temporary casual people in place of the permanent. So therefore, first thought would be the fixed term employment should be, the fixed term employment should be a justified employment because it has its own objective purpose. That if it's linked with some requirement of an assignment, or it is linked with the time, or you have some temporary contract with the clients, or you have a project that's going to finish in some defined period. So that is the time when you engage fixed term employees. Now nothing has changed. So that has been a lot of debate, and people are so happy that fixed term employee given gratuity. and then really linking with as if the fixed term employment is now permitted on in all situations. But that's not the case here. Fixed term employment is still the same law right now in the new law. The fixed term employee only will get the gratuity. That's the only change. So that's this part of it. And next, coming to a very interesting provision in the Code of Wages, that's the concept of receipt and pay. If you see, there's a provision, there's a Rule 55, which talks about that contractor has to be paid the amount before he has to actually pay to his employees. Now, this has posed a very, very serious, challenge for all the organizations, because we usually have the contract with the contractors where we define that their invoices will come, then we'll scrutinize the invoices and the payment term would be 60 days, 30 days, whatever. But now a situation has come where the contractor has to be paid so fast so that he gets the money before he pays to his employees. That's a very, very important, crucial, aspect of it. And where is the challenge is that, whether now you're making the payment, you will have to really devise the cycle so fast. Second is where the contractor's agreement is terminated. And you don't know when you pay to the contractor whether he is actually going to pay to his employees, or if there is any other challenge. So for us, the contractor is concerned and he actually disappears. So there are a lot of, now the challenge would be or the recommendation would be for that you will have to tighten the contracts, or the security, that concept has to be developed where you take the security deposit, or when you make the payment, even if he doesn't pay or if he really runs away, that you have that amount which you will use even if he doesn't pay to his employees. I think that is, I would see, this is a very, very important part of it. Second, I would see that the concept of bonus. Now there is set off, you all know that allocable surplus and all that. So then the calculation has been slightly varied, how much would be allocated. So there is some variation. I would not get too much in detail on that. But the bonus is where, the new concept in this has been brought, that you can the employee can be disqualified. There is an additional where there's a conviction on the sexual harassment of the person. So where, the person can be disqualified. Second is that, the concept of fine and damages. It has been limited to 3% of the wages with a limitation of 90 days from the cause for doing so. So the employer has a right to, impose fine and damages looking at the situation. And second is that you cannot really rake up issues which is more than 90 days. So that is a balance which has been, laid, where the employer has a right to do it. He has a right, but it's limited so far as the percentage, and it is also so far as the time is concerned. So then next is where the concept is penalty. So the 10 times compensation for non-payment of minimum wages. There is a concept of collective bargaining. I think this is for the first time in the labor legislation, if you see, that wherever there's a prosecution initiated by the state against the employer for non-compliance, the first the non-compliance where he can simply offer the penalty, and it may not go up to this, what you call the serious consequence of imprisonment and all that. So here the employer can seek that the collective bargaining, and he can get it closed, but it is only available for the first offense within a period, they have defined it 5 years, and subsequent, if it gets repeated within that period. So this provision is not, this liberty is not available to the employer. And further, the web-based inspections, which is online, that is also where the person can the concept of inspector and facilitator has been introduced. Now they wanted to give it a color or make it in a very new avatar, where the inspectors are not seen the high-handed inspectors only; they are facilitators also. So the concept of inspector and facilitator, and there's a web-based inspection. Online, the documents can be called. Online, you can submit the documents. So it will head towards more transparency. We have seen the digitization of these inspections or dealings with the authorities has made it better and more transparent and more comfortable for the compliant organizations. I think this is so far as the code on wage is concerned. I will leave this. I will not go in further details on the code of wage. So far as the code on social security is concerned, I will rush through these few points. Let's say the wage, the same definition as you have in the code on wage. The employee I was just referring to, that it is the same similar kind of a definition where it excludes the apprentice, but it has added the indirectly or the hired or people hired through the contractor, and the workers not defined as in other codes, but the gig worker, home-based worker, platform worker, unorganized workers have been included in this. And something very important, interstate worker has been defined. And interstate worker has given more clarity. We're always having a debate whether the interstate worker, the earlier it would apply to the principal employers or not. Now here, it's very clear where the person is employed directly or through the contractor from one state and employed for the other state. Or even the employee, if he comes from one state and gets an employment in another state. That is also been, there is some compliance requirement so far as the agreement and all that. There's nothing further burden on the employers, but there is a compliance so far as the data is to be submitted with the government. The employees provident fund, if you see presently, the authorities would rake up any period, any liability. So the limitation of 5 years has been placed for employees provident fund if the inquiry proceedings have not been started. So this is a very, very welcome step, because otherwise the employers would really be asked to pull out the record of 15 years and you had nothing to say on that. The employee state insurance is also, there's a voluntary coverage where there's a consent by the majority employees. So that's also there. Some stringent provisions for EPF, the non-compliances, but it's more emphasis on the penalty. But it's only the subsequent repeated non-compliance where the concept of imprisonment has been more, it's only the imprisonment in that case. And so far the facilitation and all that, centers have been also provided here for the gig workers and other workers. So I would leave it here, and then I don't want to take much time.
Thank you, Anil. In fact, Anil, you have addressed the area where there was lots of noises, and in fact, what we hear is the noise on the wages. And in fact, that was the sample that we saw here. While you were responding, lots of questions I saw was coming related to wages, floor wages, everything. And you have answered this very nicely, Anil, with the example that you gave. You presented scenarios and explained that what is the exclusion, what is not excluded, what is 50% cap, why is it relevant. So I think it would be easy for the working HR professional to understand the implication and how does it impact. So per se, the 50% cap is harmless, but then when you look at the implication of where it's going to impact on gratuity, on PF, on the salary structure, so I think that makes sense. And thanks, Anil, for explaining this in so much of with such clarity. You also explained floor wages and minimum wages, and just to give a perspective, I'm sure people would be knowing that India probably has got the highest number of scheduled employments. And I was surprised, 1500. So we have got 1500 wages. So with the new wage structure, minimum wage thing coming, the demon called scheduled employment will go, which had a pre-independence legacy. So lots of things which we have been carrying forward from the pre-legacy, pre-independence day. The world has changed, but then we were carrying the old things. So I think that will go out. And thank you for touching the sales promotion employee bit. In fact, sales promotion is again one area where lots of HR professionals will be impacted. And why? Because the policies will have to be changed. So we had policy of 30 days earned leave for the employees. Now it has to be relooked, because for sales employee, the EL is one every 11 days. So working hours has changed. Working journalists, their working hours is different from the normal working hours. So HR policies, in fact, the HRMS softwares, lots of changes will have to be, lots of things has to be relooked with the new code, with the new laws coming. You also discussed about fixed-term employees. So I think we will be able to come back to you with a short clarity, Anil, on how is it going to work. More would you like to say, advise us professionals to be cautious about the fixed-term employment? As you rightly said, there is a risk of a trap of getting into quick fixes and taking the fixed-term employment route. So it will have its plus and minuses. And as you rightly said, the intention, the right logic, intent of why it has to be, why it is implemented. I think we should be having clarity on that. You also discussed about interstate migrant workmen. Anil, one point I think which I wanted to bring in here is, in interstate migrant worker, earlier the accommodation part was not included. Now the law says that the employer will have to ensure the accommodation of the worker. If there is an injury, the labor authority has to be informed of both the states, the state where this person belongs to and the state where the person is working. So this is going to be a bit of a activity for the employers, and we unknowingly we hire interstate migrant workers, especially when we go to campuses to hire sales people. We in fact hire interstate migrant workers, and now, as you rightly said, Anil, the law has clearly defined interstate migrant workers. We need to be a bit cautious and look at our policies on that. But thank you, Anil. You have touched so much of the critical points. Anil and Ravi, I've got lots of questions people have asked, but I think I will just go with a brief round to you all and get some clarity on questions which I think will be impacting us very, very highly. Tell us more about the service sectors, the ITS industry, the e-commerce industry. How is labor law going to impact them? Maybe something on bullets, if you can take us through.
You're asking me?
Any one of you. It's
see, as far as the ITs is concerned, if you have seen the judgments of Honorable Supreme Court and various high courts across the country, the fact is that, I think a lot of advertisement has been done that there's going to be a huge new impact on the ITES or the gig workers or the online workers or the platform workers. But if you read through the judgments of Honorable Supreme Court, the judgments of various high courts, all these workers, if they are full-time working in an organization for 8 to 9 hours, at least in a day throughout the month, then they would always be covered. So there is nothing new that the code is doing for them. They were always covered by the provisions of Employees Provident Fund Miscellaneous Provisions Act 1952. They were always governed by Employees State Insurance Act 1948. They were always entitled to the payment of gratuity. They were always having the benefit of bonus. If they were through a contract labor, they were also having, the benefit of provisions under Contract Labor Regulation and Abolition Act 1970. What merely the court is doing in respect of ITS industries, platform, gig is that all the acts are coming into 4 courts. But there is one positive change which is going to happen for IT companies and the other such companies is that because What are the non-core activities? You know, the support services, the watch and ward, sweeping, cleaning, gardening, courier services, catering services. If the organization is not primarily involved in those services, and those are only the support services for the organization, then the contract, the government, the appropriate government under contract labor cannot issue a prohibition notification. So ITS companies or any other industry can freely use contract labor without a fear of prohibition notification. Then another change, which, you know, we cannot really predict right now, it may happen, is that, you know, there is a lot of hoo-ha about gig workers and platform workers. So similar principle as we have for IT industries. And if you read the judgment of Harihar Polymers of Honorable Supreme Court, it says if somebody is working as a casual worker, as a daily worker, he's just coming to your organization for a few days. I just saw somebody has also asked the question with respect to casual worker, daily worker. So Harihar Polyfibers in Supreme Court says that even if somebody is working as a casual, temporary, daily worker in your organization for a few days, for a few weeks, for a few months, he would be entitled to PF ESI gratuity. Now, what new change may happen is that, you know, normally these people like Zomato, Swiggy, they may not have full-time employees. They may have a person traveling on a vehicle 2 hours in one organization, 2 hours in another organization, 3 hours in another organization. So probably what the code means is that such part-timers will also be entitled to the benefit. I'm not sure of it now. This we will come to know after the code implements. For full-timers, there is no change. It is as it is. By virtue of judgments, they were already having these benefits. With respect to construction workers also, there is a change, which is that if there is a construction work happening below 50 lakh of rupees, then they would not be covered by the Building and Other Construction Workers Act, and therefore they will not be liable to pay cess, which is a huge amount, that is 1% of the cost of construction. Even with respect to interstate migrant workers, there is no change. It's just that definition has been clarified, and it will now include people which the employer hires themselves, or employees come on their own, or employers hires through a contractor. But even if this was not defined earlier, people through contractor were always covered and having the provisions, having the benefit of the labor law provisions. So there is no change as such. It's just that defining the core activities, non-core activities, things have become more smooth line for the management. And yes, part-timers may have some benefit. The big change is basically for the media industry and for the cine workers. That is my take on it.
Yeah, I would also add here, so far as ITS companies are concerned, now we have employees being, outsourced. You engage people even in the core areas. You have IT engineers and working with an ITS organizations in their core areas. Now, if that happens, then what she also says that, she has referred to that the prohibition in the core areas and the other areas is absolutely fantastic. But core areas could be a challenge. It could be seen as the people engaging in the core areas, and that could be prohibited. If, let's say, an IT company is formed essentially for that purpose of that kind of whatever business they're doing, and if you're hiring the people, what you could otherwise hire on your own, and if you're getting it from somewhere, so I think that will be some area that needs to be really looked at. Maybe you end up actually engaging in the core area, and they turn out to be, the contract labor. Only difference would be whether they fall in the definition of worker or they fall in the definition otherwise an employee. If they fall within the definition of worker, because engineers also, if their profile is which is mere technical and is not something which is creative in nature, and that they could be considered as workers, and if that flock is actually brought in by some other company and they work for this organization, ITS, so that is where a challenge could be. We will have to watch it out for that. What they have provided is they will appoint an authority who will decide whether a particular activity is a core activity or not. I think every state has to appoint that. And second is, so far as human resource professionals are concerned, they will have to pull up their socks, and so far as the compliances are concerned. We talk about works committee, we talk about grievance Russell committees. We talk about standing orders being certified for them. Now it's not, it may not be linked only with the industrial establishments, what we have presently for the Standing Orders Act. Now it will be, if you cross 300, and then these requirements would be there, irrespective of the fact that whether you are industrial establishment or you are a mere establishment like any other IT or service industry. So I think those areas where the compliance would be very, very a challenge. I think people have to design and people have to be very alert on that account. I think that's something I wanted to add.
So now, Anil,
one more,
yeah.
So far as the gig workers and the other workers are concerned, let's say you have Zomato or Ola or other people. Now they will have the difference would be whether do they have the right to really shut down and be under the control of somebody asking them to work today. I'm not available today. I think that will be, adding to what Raviji has also referred to. That will also be very important to consider. If the Ola driver puts it off for the day or puts it off for a half day, not available and does not want to work, I think that will be a very important criteria. Whether traditional relationship of employer and employee gets created somehow. I think that's something very important.
Sure. So now Ravi and Anil, we will get into specific questions. We have got lots of questions from the participants. So the question which I see, which I will take first is, are IT engineers covered under the definition of worker under the ID Act?
So ID Act section 2 small s of the 1947 ID Act says that anybody who's doing technical, clerical, mechanical, operational, skilled, unskilled, semi-skilled, right, he would be a workman category employee. In fact, you can read my argued judgment for Delhi High Court. This was by the name of Jetlight versus Captain R. Khosla. This was of a case of a pilot, and he was drawing a very huge salary. And
we have both done that. I have also.
Oh yes, of course. Of course, you're right. We did it together. So we had the privilege of representing Jetlight and Sahara earlier, and both said that irrespective of what the salary is, even if the salary is running into huge packages of lakhs and crores, merely because the duty is technical in nature, he would be a workman. However, if there are other co-pilots working under the pilot, there are air hostesses and other staff working under that pilot, then he would not be a workman. So similarly, for the IT industry also, if your IT engineer is merely working on the computer, he is doing technical work, definitely he would be a workman either under new code or under the prevailing laws. But if he's having supervisory duties, if he's having managerial duties, if he's having administrative duties, and you can prove it, what are managerial duties, administrative duties, supervisory duties, like he's marking attendance, leave, salary, PF, ESI, taking disciplinary action, his faculty of mind is involved, it's not a stereotype job, then that would of course not be a workman. For this purpose, you may want to refer to this judgment of Honorable Supreme Court, very interesting judgment, Ajit Singh Sonipat Sugar Mills. If my mind goes right, the citation is 2005, volume 3, SEC, page 232. Also, there is a judgment of Honorable Supreme Court by the name of H.R. Adyanta. And you may also read one more judgment, which we had the privilege to argue, that was Yadeshwar Kumar versus Bennett Coleman, where duties were laid down as to what would be workmen and what would not be workmen. So software engineer, IT industry, merely doing technical work, no managerial, no administrative, he would be a workman. And our suggestion to people is that you keep your HR records very particularly kept. If somebody is doing administrative work, supervisory work, have those emails, have that designation, have those papers properly there in the file, HR file of that particular person.
To add here, I would also add here that, when you see the definition of 2S, like, as was beautifully explained, there's one more concept of creative functions. What Raviji was also saying, where faculty, the mind is applied. The creative, the concept has been built by the courts. There is a Sundarbal judgment, Bagh Bhavan judgment, where they've said, we have these days, let's say, people working in a very flat structure. People are not reporting to. There are software engineers in a corner doing something. Now, there will be a thin line between a normal engineer working on a computer, simply assembling something and forwarding, there would be someone who's actually developing software, or he is doing something which is a creative function. That concept has been introduced now, and that's what the courts have said, that these creative, let's say you have teachers, you have doctors, you have lawyers working. So, or similar, that analogy, where the IT people who are developing software or who are doing something very niche, specialized. So those people will also be out of the, purview of the definition of workmen. And that could be also applied in these, this industry, where people with mere technical stereotype would be workers, and people doing creative functions could be taken out of it.
So essentially, it is the definition.
Here. Can I
Yes,
just add
please.
one
Yeah,
small thing?
yeah, yes.
So, if there is a professional, then there is one judgment you can actually read. It's on Google also. NL Vesh versus Dr. Shroff Eye Charitable Hospital. That was also apparently argued by us. That was the case of a doctor, right? And the Sonipat Sugar Mills judgment I referred to, that was the case of a legal assistant.
That's
so the
right.
case of professionals like doctors, lawyers, and even politicians, I've argued for politicians also, when they start claiming employment benefits, that would not, of course, they would not be workmen. However, like Anilji said, that somebody working in IT industry and merely doing technical work, that would be construed to be workmen.
So essentially what you are telling is the new codes is focusing more on work. It's not on the person, it's on the work they do. If the work is all the skilled, unskilled, technical, operational, then it would be workers. If they're doing administrative and managerial, it would not be workers. Fine. So I have got one more relevant question here. If an employer is hiring consultants and external auditors for process improvement in its premise, would the auditors and consultants come under Contract Labor Act?
So, this problem often comes. And in fact, I have recently received a very different kind of problem, which I will share. If you look at it, I always looked at this problem from the labor law angle. So if I look at it from labor law angle, then of course, because somebody is working with you for 8 to 9 hours in a day, his contract says that he cannot, by the time when he's working for you, simultaneously work for another company or another employer. He works for about 26 days in a month for you. Then merely calling him consultant, you cannot take the labor law benefits from him. Now, this is from the labor aspect. However, if you start adding the clauses that no, he's not a full-time employee, or he can simultaneously work for other organizations, then that would be a case of a pure consultant, and then he cannot claim labor law benefits. This is from the labor law angle. Now, a ticklish problem which I received just a few days back was that while they were treating him like a consultant, but at the same time, they were paying his TDS like a professional. Right? Because they thought by paying TDS like a professional, they can get away with labor law problems. So our suggestion is that be very clear. If you're making, somewhere कानून के हाथ कहते हैं ना बहुत लंबे होते हैं, so कहीं ना कहीं हम जाके फंस जाते हैं. So वहाँ पे you are paying TDS of a professional. यहाँ पे you're not giving him labor law benefits. So PM authorities after their life that you are, treating a full-time person like a consultant, not giving him proper this thing over there. Income tax authorities are after them that you are not paying proper tax. So our clear suggestion is that if you are making somebody work full-time, for throughout the month, then treat him like an employee, even if you are giving him nomenclature of consultant. But if you really do not want to have him with you for years together, you actually want him as a consultant, then insert this clause in your appointment letter, which I'm suggesting that he can simultaneously work for other organizations, and he is not only bound to work for you. And don't really make him work for hours together and days together like that. Be very fair in the dealings.
He has not to work like any other employee, where you have supervision, you have control. So consultant would not be, there's a fashion of having 100 consultants, 100 retainers in the office, and even office executive is considered, treated as a consultant. So consultant is someone who has some kind of specialization. You can't have consultants in all the areas. So if someone is in the office doing some basic work and you treat him as a consultant, that will be very superficial. So, the actual working and the contract has to be, which actually says that he's a consultant, is a non-exclusive kind of a work.
Okay. I have a very good question from Sanjeev Kumar. He says, post-pandemic, lots of companies, especially service industries, are moving toward work from home or work from anywhere. Does this course going to provision some sort of governance to monitor fair wages and other compliances, which is based on minimum count of employee working in premises attached?
See, working from home does not mean that you can be paid below than what the government has prescribed for the person. Whatever the minimum wages have been prescribed, that has to be paid. That is one part of it. Now, if you're paying your employee beyond the minimum wages, you have a CTC, a higher CTC for him. If it is a workman level employee, now note this, because this is where the importance of labor lawyers like Bhattji and ourselves come. If he is a workman level employee, note this provision of Industrial Disputes Act, Section 9, capital A of the ID Act, which says that no service condition of an employee can be changed to his detriment unless there is consent of the employee, unless there is a meeting, etc. But if it is a non-workman employee, it is a manager, he has got threat of termination or any other adverse impact, of course, you can negotiate with him, call him that, look, you're working from home, we will not pay you for uniform, for your conveyance, or your other things. And there you can kind of reduce the salary. For workman level employees, you may reduce things like uniform conveyance, but not really, not many changes, even if he's working from home.
Right.
Minimum wages you cannot reduce unless government allows you to do it.
The challenge would be something further. Let's say you have an office in Gurgaon, right? And the person was actually working in Gurgaon. Post-pandemic, you permit them to work from, let's say, Lucknow or the Assam or the any other place. Now, the challenge would be how the compliance regime would be for that, because the companies would usually say, since he is actually tagged with this office, whether it's so far as the leaves are concerned or other benefits are concerned, what is that would be applicable? So that is the challenge what people would face. So if you talk about, there's a Shops and Establishment Act. So while we are talking about other legislations, we have to also talk about the state legislation, which is the Shops and Establishment Act. And that is every state has those legislations that provides the working condition of employees in that state. And that has some backdrop of the conditions of that place, the requirements of that place, where the benefits or working conditions has to suit. Let's say now the person who was in Gurgaon, he is getting leaves, n number of leaves. When he goes to other state and he is actually permanently now almost stationed there, now you don't have a temporary concept of working from home. So you have certain categories, they would now be permanently stationed there. Or there are people who are hybrid, then few days here and few days there. Now the question is that what kind of leaves? What is that minimum wage? I think that will be a lot of exercise for all HR professionals. That what is going to apply is that cosmetic. You tag him with this office, but physically he is somewhere else. The answer would be that where the person is actually stationed, physically present. I think that if he is permanently there, that would be an area, a lot of debate in coming months once the code comes in.
Okay. So, Anil, now I have a question for you. So this concerns code of wages. Nilima asked that an employee drawing salary of 1 lakh per month will be covered under code of wages and need to follow basic and exclusion of salary criteria.
Absolutely, because see, when you say gratuity provision, it has nothing to do with the wage. So it does not have a ceiling of any, in any manner. So if the person, let's say, has 1 lakh rupees, so 50% has to be for the purpose of gratuity. It may not be relevant for the purpose of EPF. Maybe, post beyond 15,000, it would be the voluntary contribution. But so far as the gratuity is concerned, there is no ceiling. So that has to be followed in that way. So therefore, the impact would be for the gratuity in any case.
Okay.
I think Anilji, gratuity has a ceiling, as you may add in.
Yeah, amount.
20
That's
lakhs.
right. So the upper ceiling, so far as the amount is concerned,
Yes.
how much, if it exceeds, let's say 20 is there. So actual calculation. But so far as the formula is concerned for arriving at that amount would be same for people getting salary of 15,000 or 1 lakh.
Satya Prasad Das has a question, Ravi. When labor codes are coming into force?
Oh, that's the $1 million question. Well, I don't know if you people are aware. I've been connected with ministry and the state government, but I don't know if you're aware. There's a latest notification that has come of the. My father is here and he's telling me कि तेको तो जोशी होना चाहिए. Well, okay, but coming to the point.
First of all, let's say good evening to him.
Good evening. Yeah.
It's very difficult to really speak when he's around, to be honest with you.
So the thing is, there's this latest notification that has been announced by the ministry on 23rd of March, and I'll just read it out for you. That notification merely talks about as to, 27, 23, 18 states and UTs have pre-published the draft rules, and there have been widespread consultations that the codes are being finalized. So my earlier prediction was that it should come right after the elections. And now this notification exactly came on 23rd of March. So probably, just anytime, because almost all these states are done with their rules, like 27, 28, 27 with IR code, 28 with SS code, 23 with 3 codes, etc., etc. As soon as all these states are finalized with their rules, they should be announcing it, unless there's a hoo-ha like we had in the farm laws time.
We are hearing that, code on wage, I don't know how authentic it is, code on wage and industrial relations code are the somewhat controversial so far as the, many 300 no permission required for closure, retrenchment. But people say that maybe social security code and occupational, these two may really sail through faster than the rest, code on wage and industrial relations. But that's also, we don't know how much correct.
And just to add to your point, Anil, the government has already started working on the technology platform for this SS code. In fact, there is a portal running called National Career Service, which is going to be probably bigger than LinkedIn, and all the job posting is happening. They're going to link eShram and Udyam portal into this. And eShram is already starting creating the database of unorganized workers. Gig platform workers have also started registering into that. So the groundwork probably, and logically, social service code would be the easiest to be implemented.
That's right.
There is one more thing in that NASSCOM that you're talking about, in that not just jobs, they will also provide training also, so that, we have got more serving hands. And there is this project of government by the name of Vision 2047, with the motto saying that more governance and less government. So you're right, things are going to practically develop in the next few months.
Right. Anil, I have another question for you. This comes from Sanjeev. His question is, variable pay is not guaranteed as it depends on employment and company performance. Will gratuity be made on wages, including gratuity? Will gratuity be made on wages, including gratuity?
Are you talking about the new code?
Yeah, so he's asking about the new code.
There is the exclusion, what I was talking about. It talks about the exclusion part, or the the bonus other than the statutory bonus. Now the question is, there is, to my mind, when you talk about something which varies, and even if you see Provident Fund judgment of Supreme Court, the Surya Roshni, that also talks about what basic wage where there's a varied allowance. So that may not. The point is, if let's say an employee in the previous month, he earns, let's say, X number of the variable allowance, and the next month he is to retire or he leaves the employment. So are we going to calculate gratuity at that rate because it's the last drawn wage? Now, let's say if he earns more earlier, then he earns less, or he earns 2 months or 1 month before on a higher. I think variable should not be considered for the purposes of the gratuity. So I think, but that I would still leave it to a debate whether it will, because point is that it will be a very fluctuating. Reason is that a person earning more and earning less, what could be the basis of calculation? I think that's something to be seen how it will come up.
Right. One more question, Anil, on PF. So this comes from Ravindra. The question is, please clarify whether this new code will be applicable to foreign nationals as well. he's asking about international
Yes,
workers.
yeah, that's right.
It would be applicable.
International workers provision came way back on October 2008, and since then it's there, and even in the new code it's there.
That's
And
right.
you in that, in fact, under PF Act, you can cap PF up to a salary of 15,000, right? Somebody was saying if it goes beyond 15,000, I would want to answer that there in the chat box. If once a member of PF is always a member of PF. So today, if your salary is below 15,000, tomorrow it becomes 20,000. If once you are a member of PF, you would always remain a member of PF unless you've left the employment. There is a 2 months gap, and you've withdrawn the deposited PF. And yes, beyond 15,000, you can cap it to 15,000. But for international workers, there is no cap. The PF has to be given on basic DA and the retaining allowances,
Okay.
unless there are utilization agreement with various countries.
Right. So I have one question from Madhuri. The question, so she is giving a scenario. The question is, if a worker visits a factory for 2 days for maintenance work, will the labor laws, will the compliance requirement be required for him?
No, I missed your question.
The
I am
question
Dr.
is,
Madhuri here. Yeah. Hello. I am the factory medical officer. So many a times what happens, the compliance of factories rules comes into play where the pre-employment medical examination is a mandatory before the worker enters the premises to conduct some work or handles any hazardous equipment. So factories rules requires pre-employment medical. But what happens sometimes, now the definition of a worker in the factories rules says that anyone entering the premises for purpose of work. So many times what happens, a worker enters the premises for handles the equipment and tells us that this is for maintenance work, which is only 1 or 2 days duration. So the pre-employment medical employment need not be required to do. My question is, the new code, does it mandate the worker who is entering the premises, who is not employed by the company, employed by a third party, but entering the premises for hazardous work for a duration of 1 or 2 days? Does the factories rule apply to this, or it's a definition? Because the management was telling me that look at the definition of a worker. We are not employing this worker. He's entering the premises for 1 or 2 days, because they do the pre-employment for rest of the workers who are working under them for a period of 6 months or 1 year under contract or permanent. But what about a worker who enters for 1 or 2 days? Does the factory's rule of compliance of pre-employment medical apply to this? Is he required to submit the pre-employment medical to the occupational health center, to the doctor? Does it apply for a worker for 1 or 2 days?
For your question, you'll have to take appointment from Anil or Ravi.
Okay, but my question is very simple. When a worker working in a company for 1 or 2 days, does the compliance of factories rule of providing pre-employment medical?
There is no rule under Factories Act that you need to take his medical if somebody is merely coming for 1 or 2 days. In fact, even if he's coming to you for 2 years, you were not required to take a medical before the pandemic. Let me just complete. If there are workers working in your premises, then the provisions of ambulance, medical, etc., they are there. But if he's a supervisor or a person who's just coming on contingent basis of 1 or 2 days, medical is not required. If he continues to work for 10 days, 15 days, even then medical may not be required. There may be provisions for PF-ESI. That is a different arena. But for Factories Act, the medical is not required.
No, my question is, factories rules does not mention the duration of the work. Anyone entering the premises for purpose of work has to submit the pre-employment to the occupational health center or to the factory.
So
HR.
For that matter, it would be anybody entering, like even a courier person entering. If you take it to be anybody entering, that would mean even a person who's coming to give you a burger, or somebody who's
not anybody. No, anyone entering the premises.
I think, Doctor, I think you can take this question offline. In the interest of time, I have just one quick question before we sum up. So, Anil, this is to you. Ravi Prasad asked that Anjali, he is giving a specific case. Anjali, a software developer, also has an element of creativity in his work. So it's very difficult to differentiate between technical work and creative work in respect of a software engineer is concerned. Your take on it?
I think, if you see that what you call individual contributors, and there's a new concept. The point is that, do you have that, contribution where you have some discretion, or people, take it as your, expertise and really work on that? or it is simply assembling the information. I think you would be in a position to make it that there's a difference between a mere stereo kind of a job or a person actually creating something on his own without anybody actually telling him. It is a specialized area, whether he's applying his mind beyond. I think that would definitely make a difference.
Right. So we would close this. So I think we had good discussions, and thank you, Anil and Ravi, for bringing in all the perspective, practical, court judgment. It was very, very engaging, and I'm sure we have made good use of the time for all our fellow HR professional friends, seniors. Over to you, Musarraf sir.
Yeah, thank you. And I once again, on behalf of NHRD and Delhi NCR chapter and my executive committee members, would like to thank Mr. Anil Bhatt, Ravi Birbal, and Amitabh for excellent deliberation and discussion. In fact, it was like, labor laws made easy. And I could see the enthusiasm in people and the kind of questions that has been put. I'm sure that, this will have a lot of takeaways for people. And one thing I would like to share that, looking into the kind of interest people are showing on this subject, we'll soon launch several master classes for the benefit of practitioner. So thank you once again, all the people who have joined from various locations for patiently listening to this deliberation. And thank you once again, all the people who helped put up this beautiful program. So thanks a lot. Thank you once again. All the best.
Thank you.
Thank you.